I would like to welcome Tish Odell.
Thanks, everybody. Ray didn't say it, but I'm the Ohio organizer for the Community Environmental Legal Defense Fund. I've been to Youngstown several times. I love coming to Youngstown. You guys are fighters. Yes, you never give up, you don't quit, and I like that. Many of you know that we have formed the Ohio Community Rights Network here. We did that in 2013, and that's several Ohio counties coming together to form a network to work on community bills of rights and asserting their rights in their communities where they live. So tonight our speaker is Thomas Linzey. I'm very proud to introduce him. He's the Executive Director of the Community Environmental Legal Defense Fund. He's actually the one who inspired me to change my life 5 years ago. I don't know if I should thank you or curse you. And if you don't know about, we call it CELDF, that's the acronym for the Community Environmental Legal Defense Fund. It's a nonprofit law firm that has provided free legal services to more than 500 local governments and nonprofit organizations since 1995. Thomas is a cum laude graduate of Wiener Law School and a 3-time recipient of the law school's Public Interest Law Award. He's been a finalist for the Ford Foundation's Leadership for a Changing World Award. He is the recipient of the Pennsylvania Farmers Union's Golden Triangle Legislative Award, and he is admitted to practice in the United States Supreme Court. He's also the co-founder of the Daniel Pennock Democracy School, which has graduated more than 5,000 lawyers, activists, and municipal officials. The school assists groups to create community campaigns that elevate the rights of those communities over rights claimed by corporations. Linzey is also the recent author of Be the Change, How to Get What You Want in Your Community, has served as a co-host of Democracy Matters, which is broadcast from Spokane, Washington, and is syndicated on 10 other stations. He was featured in Leonardo DiCaprio and Tree Media's film 11th Hour, and has assisted the Ecuadorian Constitutional Assembly in 2008 to adopt the world's first constitution recognizing the independently enforceable rights of ecosystems. And he's a frequent lecturer at conferences across the country. His work has been featured in the New York Times, the Los Angeles Times, Mother Jones, and The Nation magazine. And in 2007, he was named one of Forbes magazine's Top 10 Revolutionaries. All right. I also have available, this is the latest booklet that is written by Thomas Linzey, and so we will have these available after the presentation. So, Thomas Linzey.
So, can everybody hear me with the microphone? Okay. So we came into Youngstown this morning, and it's the part of a 6-city tour over the next 6 days of the state of Ohio. So you're getting us fresh. I think that's a good thing. Tonight we're going to talk about some really difficult stuff. In some ways, what we're going to talk about tonight is very simple, because it goes back to democracy and local control and communities making decisions for themselves. The conversation tends to get very, very complicated because over the last 150 years, certain commercial actors, mostly corporations, have developed a system of law in the United States that actually deprives us of democratic control over our own communities. It's essentially that we live in an illusion. We live in a myth. And that myth is the essence that when you ask people generally, they say, well, of course we live in a democracy, and of course we make decisions that are important to our communities, and of course we have local control over things that are important to us, like stopping harmful corporate projects. But the fact of the matter is we don't. And the conversation gets fairly complex when you begin explaining why we don't. Because it's important to understand how the system is currently constructed. Because our job in many ways is to dismantle that system. We use titles like community revolution or community revolt because that's exactly what's happening in the United States today. Not just in Youngstown, but close to 200 other communities in 10 states have begun rising up in many ways against this structure of law, understanding that in order to stop a fracking project or to stop a pipeline, that you actually have to make structural change to the system because the system has obstacles and hurdles built into it that deprive you systematically of the ability to make decisions about your own community, where you live. And so it used to be, before I went to law school, I would think to myself, we're talking about issues of law, we're talking about jurisprudence, we're talking about stuff that goes back 150 years, and corporations and how the laws get manipulated. I used to think that was a conversation mostly for lawyers, because another myth or illusion that we have in our society is that change is made by lawyers. Silver-tongued lawyers going in and making arguments to judges. The problem is that in talking to lawyers over the years, we've learned that that's the last place that change is going to happen. That the lawyers are not the change agents, that people in communities are the change agents. And I was reminded, last year when I saw this great t-shirt for sale, about my conversations with lawyers over the past 10 years to talk with them about the need to change the system of law. And generally you meet with glazed over eyes and just complete misunderstanding of how the system operates, or in fact a need to operate within the system to try to get what we can get from the system rather than asking what we actually want. And the t-shirt had a slogan on it that said, "I can explain it to you, but I can't understand it for you." So that's pretty much where we ended up with the legal community in terms of trying to explain this stuff to folks. So before I start tonight with the bulk of the talk about it, I just wanted to thank the Dr. James Dale Ethics Center and the Ohio Community Rights Network for sponsoring tonight, but also the tour over the next 6 days. And we're going to be talking more about the Ohio Community Rights Network. What is it? Where does it come from? Who are the folks responsible for managing it, running it, what are its goals, those types of things. But to start out tonight, I wanted to talk about how we, started out 20 years ago, fresh out of law school, not challenging the largest corporations in the world, which is pretty much some of our work today. But we didn't start in that place. We didn't wake up on a Wednesday morning and say, hey, we're going to take on Monsanto and Waste Management Corporation, some of the big fracking corporations of the United States. We came out of law school thinking, hey, the problem is not the system of law in the United States that we have to work through. The problem is that we don't have enough lawyers enforcing the existing laws that we have. The conversation among lawyers sometimes, and coming out of law school, the conversation with law students, is that we have the best environmental laws in the world. In fact, our environmental laws are so good that we export them out to other countries, right? We take our environmental lawyers and we send them out to other countries to actually replicate our regulatory system of law, our environmental laws in other places. So the laws are so good that we're in demand across the globe because we send these folks in to replicate our systems of environmental law. So when you come out of law school, you think, well, if the world's falling apart and we have ecological destruction, stuff's getting a lot worse day by day, whether it's global warming or clean water issues or clean air issues or whatever, that the problem must not be the environmental laws that we have in the United States. The problem is that we don't have enough lawyers enforcing those laws. And so back in 1995, and the numbers are shockingly pretty close to the same now, that in 1995 there were only 200 full-time public interest environmental lawyers in the United States. So only 200 full-time public interest environmental lawyers in the entire country. 200. So for a community group, an environmental organization, a neighborhood group, to actually get a lawyer to sit down and talk about a permit or to talk about some kind of environmental issue that the community group was dealing with, today can cost you between $500 to $1,000 an hour. That's the market rate of some of the specialty environmental lawyers out there. And so community organizations, back in 1995, when we were coming out of law school, really had no place to access legal help. And so again, we were framing the problem as not enough lawyers doing this kind of work. So we decided to create the Community Environmental Legal Defense Fund, because that last year in law school, we were being approached by groups across central Pennsylvania who were dealing with toxic waste incinerators and proposed corporate factory farms coming in, and land disposal stuff like sewage sludge being dumped on land, which is a big issue, or corporate water withdrawals, or plans to use genetically modified seeds in different communities. And these rural groups were coming to us fresh out of law school because they had no other place to turn. They couldn't access legal services anywhere else because they didn't have the financial resources to do that. And so we decided fresh out of law school to launch the Community Environmental Legal Defense Fund. And CELDF was intended to provide free legal services to these community organizations that couldn't otherwise afford those services. As you can imagine, when you hold out your shingle and it says free legal services, in an arena in which legal services have been very hard and expensive to come by, that you get the line wrapped around the block like people waiting for concert tickets and your phone ringing off the hook, and pretty soon, in Pennsylvania, we were representing about 100 organizations, so 100 community groups across the state of Pennsylvania, fighting various things, these toxic waste incinerators, any of the thousands of different single issues that face communities every day. And those clients would come in the door generally through a phone call. And the phone call that would come in the door was a rural community somewhere in central Pennsylvania that would call and say, hey, we have a 15,000 hog factory farm that's been proposed for our community, and we don't want it. We want to say no to it because we don't want it here. We understand that factory farms and the corporatization of agriculture has caused a variety of problems. In the United States, for example, we've lost 300,000 family farmers over the last 20 years as a result of this concentration and corporatization of agriculture. 6 corporations control 70% of poultry production in the United States. 6 corporations control 80% of hog production in the United States. 1 corporation now controls 80% of cheese production in the United States. It's Kraft Corporation. So this corporatization or concentration of agricultural resources and the agriculture industry into a very small number of corporations caused a lot of problems. One of the phone calls, some of the phone calls that came into our office dealt with this corporate factory farm issue, and these folks would say, we have a 15,000 head hog factory farm that's going to be sited in our community, we don't want it, we want to protect our farmers, we want to protect our air, we want to protect our water. And we would be on the receiving end of those phone calls, and we would say to folks, hey, we're with you. I wouldn't want a 15,000 head hog factory farm next door to me either. But the law is written in such a way that you don't have the power to say no to that factory farm coming in. And sometimes that sounds surprising to folks, because they'll say, well, of course we have the power to do that within our own community. We have zoning ordinances and zoning rules, for example. Someone will always put up their hand and say, well, we have zoning rules, and that allows us to ban certain uses within our community. Well, not quite. Zoning ordinances are about separating out incompatible land uses from each other. So you'll be separating out residential uses from industrial uses from commercial uses. But if you try to use a zoning ordinance to actually ban a legal use, in other words, state issues a permit to a corporation to put in a certain use or project, it's a legal use, L-E-G-A-L, that the law itself, the system of law, prohibits the municipality from banning that use. So you can't use the zoning ordinance to ban the use. You can't actually pass a one-paragraph ordinance that says no big box stores or no factory farms or no frack operations. You can't do that. It's the way the law is written. And it's been that way for the past 150 years. So you can ask the corporate lawyers, you can ask the environmental lawyers, it doesn't matter who you ask, you'll get the same answer. It's been well-settled law for a long, long time in this country, that if the state or federal government has designated something as a legal use, and again, almost everything has been designated as a legal use. Low-level radioactive waste sites, legal use. Fracking operations, legal use. Corporate factory farms, legal use. Corporate water withdrawals, legal use. These are all uses that are controlled through that state and federal permitting process. And because of that, municipalities, your communities where you live, are banned from prohibiting those uses. So it's been the law for 100 and 150 years. So the folks on the other end of the line who were faced with a 15,000 head hog factory farm or one of these other projects would say to us, okay, well, if we can't say no to it, what can we do within the existing system of law that we have? And we said, we're so happy that you asked, because that's what we were set up for. And we would say to the folks on the other end of the line, we would say, you're so lucky you found us because we can provide free legal help. What we're going to do for you is we're going to take the permit application that was submitted by the corporation to the environmental agency, and we're going to review that permit application and argue to a judge that the permit never should have issued in the first place. That the environmental agency that issued the permit to the corporation made a mistake. They made an error. That somehow something in that permit that they issued shouldn't have been issued because it violated the regulations. So we would go back and become experts on the regulations, on the land use regulations, or on the toxic waste incinerator regulations, or on the factory farm regulations. And sure enough, most of the time we were able to find some kind of mistake, a gap, a omission, or a deficiency in the permit application. So the agency should have never issued the permit in the first place. So just to be really practical tonight, if you want to put in a toxic waste incinerator in Pennsylvania, and I know many of you do, it's been your dream for a while, you have to post a bond for the roadways that are leading into the toxic waste incinerator to promise the state that if there's any damage to the roads that you're going to take care of it financially. So you have to post a bond. And in 1995, the bond was around $100,000. So we would go back and look at these corporate permit applications, and lo and behold, they would have submitted a bond, but it wasn't $100,000. It wasn't the amount that it needed to be within the regulatory structure. Or the application needed the signature of the president of the corporation for it to go through the application process, yet the secretary had signed the papers. Or it needed a hydro study, a hydro or aquatic study to figure out whether it had an impact on waterways where the facility was going in. And it turns out some of these applications had studies that were 15 or 20 years old. So we would find something wrong with the permit application, which has been the history of environmental law practice for the last 20 years. And we would go into the judge and we would say, Your Honor, under section little 2, little c, little I, little 2, little a, little Roman numeral 2, little I, little c, little 2, little I, that the signature was wrong in the application and the permit never should have issued to the corporation. And the judge, by and large, would look back at us and he goes, by God, you're right. The signature was missing, or the bond amount was wrong, or something was, gap, omission, or deficiency in the application. And so I'm going to kick that out. I'm going to override the state environmental agency, and I'm going to nullify that permit that was issued because it never should have been issued in the first place. Well, what happened next? Well, the community group that we were representing within that particular appeal would then have a victory party. So we go back to the house of one of the community leaders, and they would have, beer and snacks and pat each other on the back and say things like, we won, the system worked, right? We had a problem in our community, we came together around our kitchen tables, we decided to do something about it, we found a lawyer that could speak, cohesively, and we found a judge that was willing to listen to us, and the system works, right? The system works because now we're not going to get that toxic waste incinerator next to us. Well, what would happen 3 months down the road, 6 months down the road, whatever, is that the corporation would come back. And this time they'd come back with a new and improved permit application. And the group would come back to us and they'd say, Mr. Lindsey, we need you to do that jujitsu again that you did the first time around to try to get that corporate permit application thrown out. And we were faced with a situation where we had to look back at them and say, we're sorry, there's nothing we can do because there's no leverage points anymore. In other words, the corporation would come back and fill in the gaps and omissions and deficiencies that we had identified within the regulatory process. And in fact, we're gleeful in doing so. There were some arguments in front of the judge where after we were finished and the permit application got tossed out, that the lawyer for the law firm representing the corporation would come over to us and thank us for finding the gaps, omissions, and deficiencies because they could bill more hours to the corporation to actually fill in those problems that we had found within the permit application. At least we thought at that point that we were costing the corporations money. That by hauling them into court, they had to pay their lawyers, and the lawyers had to argue, and they had to go through this whole process. It was then that we learned that the monies that the corporation spends on their lawyers for these permit appeal defenses is tax deductible. Tax deductible is a reasonable and necessary business expense by the corporations who are putting on the defense of their permits. And then someone said to me, a long time ago, it still stuck with me, she said that the only thing that environmental regulations regulate are environmentalists. Right? Because the regulatory system, the regulatory structure, makes us predictable as to how we defend our communities. So when we actually do our activism, we don't say, what do we need to do to stop this thing? What we say is, what can we do within the existing regulatory system to slow it down or delay it or find problems with it? The problem is when we do that in this dreamland hamster wheel that we're forced to run around in this regulatory enforcement process, is that we rarely acknowledge to ourselves that the regulations are written by the very corporations that the regulations ostensibly are supposed to regulate. Right? So if the corporations who are involved in the regulatory process at the legislative level who are writing the regulations are the ones actually writing the regulations, and we're the ones that come in hoping to work within them to stop them from doing what they planned to do after they wrote the regulations to legalize the activity. How crazy are we? Right? So the definition of insanity is doing the same thing over and over and over again, expecting a different result the next time. Does it really fool us? Do we really fail to comprehend why the planet's falling apart? Right? Because this regulatory activism, working under somebody else's script that was written specifically for us, if we think the corporations are going to provide anything in that script for us to say no to their project coming in when they wrote the regulations, that's insane. But that's been the history for the last 30 years of environmental lawyering in this country. That's what environmental law has been about. And I think the place where that at least broke our camel, the final piece that broke our back in this whole process, was that at the end of about 8 years, we had a series of wins. We would go into these administrative agencies and in front of judges, and we would win that first round of the regulatory stuff, but we would eventually lose the last round, which was the most important one. And if you went into the communities that we were actually representing, like Chester, Pennsylvania, for example, you would see something that was not reflected at all in our win-loss record. So our win-loss record was 155-3, because we were winning those first rounds on behalf of these community groups. But if you walked into the actual communities we were representing, you saw no resemblance between that win-loss record and the actual community, because the community was getting the toxic waste incinerator. It may take a year longer, but they were getting the toxic waste incinerator, they were getting the corporate factory farm, they were getting frack, they were getting their pipeline, they were getting whatever they had entered into the regulatory process to actually obtain. So we weren't stopping anything at all, right? But that win-loss record made us one of the most successful law firms, environmental law firms in the United States. So we got invited to the White House one year for Environment Day. We got funding and we got recognition from the community, from the liberal progressive community. We did everything that environmental careers and environmental lawyers, that's what they want. But at the same time, it had nothing to do with reality. Because reality was the process was rolling forward and crushing these communities. And we were doing absolutely nothing to stop it. That's what environmental law is today. It does not recognize the authority of the community to say no. And in fact, it only recognizes your authority to enforce the corporation's own regulations against them. Because that's what you're doing, because they've been written by someone else other than the community and other than you. That was our version of Groundhog Day in some ways, the movie. If people have seen it, if you haven't seen it, Bill Murray lives the same day over and over again in this movie. It turns out to be Groundhog Day. Our Groundhog Day began when these calls would come into the office and people wanted to have a conversation. They would say, we have this project coming in, we don't want it. We want you to help us say no to it. And at some point, at the early 2000s, the calls, instead of deferring to us, when we said to people and communities on the other end of the phone, that you can't say no, right? So in the beginning, calls would come in when we first found it, people would say, we don't want this thing. We would say, we're with you, but you can't say no. All you can do is fight it out within the regulatory process. That at some point that changed. It was in the early 2000s that changed. And I remember having conversations with communities that were calling, and they were saying, we don't want this project. And I would say, well, you're going to get it because the law itself is structured so you can't say no. That they started to ask a series of questions. And it's those questions that actually brought us here today in many ways. So I would say, well, you can't say no to the project coming in. And the person at the other end of the phone would say, why? Why can't we say no? To which then I would reply, well, you can't say no because if you pass a one-paragraph ordinance that says no factory farms or no big box stores or no fracking operations or no pipelines, that the first thing that happens after you pass that law is that you get sued. And you get sued by the corporation affected by that one-paragraph ordinance that you've passed, that one-paragraph ban. And the corporation, when they come into court, they allege two things. The first thing they allege is that you're preempted, that the state legislature has passed a law that removes your authority to regulate or control certain things within the municipality. I don't have to explain this to you as Ohio folks, because your Ohio legislature has been very active in preempting you on all kinds of things, including fracking operations. So they would say, why is that? And the corporation, when they sue the community, would use two arguments. One is a preemption argument, to say that the state has preempted you from dealing with certain issues. The little illusion in all that, of course, is that it's the corporation that's able to use the state to preempt you. So the corporations in a particular industry area have enough power to actually run their own legislation to preempt you. It's almost like the look mom, no hands defense, because they say, well, it's the state that did it. Go complain to your state representatives and your state senators. What they don't tell you is that they're the ones driving the train to actually move the stuff through the legislature. I used to work in the state legislature in Pennsylvania. I watched as the agribusiness corporations would write bills and hand them to the state legislators, right? So the state legislature is used to preempt you, to divest you of certain authority over certain issues within your community. But there's a second tool that they have that we don't, which is called corporate constitutional rights. Corporations today in the United States are persons under the law. They have the same Bill of Rights protections as you or I do under the law. So folks may remember the Citizens United case, which came out several years ago, knocking down federal campaign finance law on the basis of corporate First Amendment free speech rights. So that case was corporations having free speech rights under the First Amendment and being able to wield those, in this case against Congress, against the federal government, to nullify federal campaign finance laws. Well, corporations use those constitutional rights every day to protect their property against municipal governments who are trying to stop them from using their municipality. How does that work? Well, the permit that the corporation holds from the state or federal government is deemed to be property under the law. It's a property interest. So when the municipality passes a law, one paragraph ordinance that bans certain uses that are permitted by that state or federal permit within the municipality, you are taking the corporation's property. Okay? Corporation has constitutional rights to protect them against that taking of property. And so they sue the municipality. And not only do they sue your city, your municipality, for interfering with their corporate constitutional rights, but they sue your community for damages in the form of future lost profits lost as a result of the law that you've adopted in the community. Okay? They're called Section 1983 lawsuits when you interfere with a corporation's constitutional rights. Okay? So the folks on the other end of the phone, if they haven't hung up by then, the communities that were calling into our office would then say, why? Right? Why do corporations have those rights that they can use to sue our community? And so we were forced to then try to answer that question and say, well, it's a result of about 100 years of the U.S. Supreme Court basically bestowing corporations with certain constitutional rights. Some people track it back to 1886, when a case called Santa Clara County was decided. That was part of it. But the Supreme Court, your Supreme Court, has been very active in the United States in finding corporations in the U.S. Constitution as early as 1819. It goes back to 1819 in terms of finding corporations in the Constitution. So it's a long history. And in fact, it doesn't stop there because it goes beyond the American founding of the Republic. English law recognized corporations as persons for certain situations. And so it goes way back. It's a concept that goes way back in time. To which the folks on the other end of the line, this time if they really haven't hung up at that point, would say, well, why is that? Why was the Supreme Court able to find that corporations have the rights of persons? I mean, think about it. A corporation is a piece of property. It's like your refrigerator, right? You can buy a corporation. You can also buy a refrigerator. This is like your refrigerator having rights, right? Your refrigerator suing you. I mean, that's how crazy the concept is. It's about a piece of property having rights. Well, the folks that founded this United States, the American Revolution and all that kind of stuff, actually believed that property wasn't capable of having rights. They thought that was the whole problem with being an English colony, was that they were property under the law as a colony. They were corporations essentially owned by England under these privileges that were given to the colonies. And so that was a real big issue during the American Revolution that somehow seemed to have washed away over the next 100 years in terms of corporations having these property rights. So again, the folks on the other end of the line, we had many of these calls, too many to count, would say, why is that? Right? Why was it so easy for the U.S. Supreme Court to give corporations personhood rights and to recognize corporations as having more rights than you? We forget this sometimes, but corporations gained full personhood in 1886. It was one of the big Supreme Court cases. Women didn't get the right to vote until 1920. Corporations became persons 40 years before women became persons under the constitutional structure in this country, right? So personhood freely granted to property and commerce, those purveyors of property and commerce, not so much to women, even when it came to the right of suffrage. And of course, keeping in mind the right to vote is a far cry from the right to equal protection and all the other constitutional rights that comes with. So the folks on the other line this way, why is that, right? Where does this concept come from? And where does this body of law come from? Well, we would try to answer that by saying that the American U.S. Constitution came from a certain place. And it came from something called English common law. And this was when England and the other colonial European powers were colonizing different places, like Bahamas and Bermuda, and places in the Caribbean. We forget that the early American colonies were corporations. Virginia was a private corporation. Rhode Island was a private corporation. Our states began as private corporations. And to gain status as a colony, you had to agree to abide by something called English common law, which was this body of law that England was busy exporting across the globe in order to extract resources and do the stuff that colonization is made of. That English common law stuff was written at the worst time in this nation's history, in this globe's history in many ways, which was it was all about extracting resources and subordinating native peoples and eliminating and extinguishing indigenous peoples. It was all that really bad structure of law, which put the right of property and commerce above the rights of people, communities, and nature. So that was the basic structure. And unfortunately, many of the lawyers that wrote the U.S. Constitution, keeping in mind that the U.S. Constitution was not a revolutionary document. The Declaration of Independence was a revolutionary document. But the folks that wrote the U.S. Constitution were a much different breed. They were post-American Revolutionary War. Most of them didn't serve in the Revolutionary War. And they were interested in commerce, property protections, exploiting the seemingly endless bounty of natural resources that they saw across the horizon. And that was the purpose. That's the basic DNA of the system that was driven into that U.S. constitutional process and structure. And so when folks ask why, why is the system built the way it is, we can track it back all the way. All the way to the basic beginnings and foundations of this system. A lot of people say, well, the system's just broken, we need to fix it. It's just a mistake somehow. It ain't no mistake, right? It was built this way. It was intended to be this way. Folks come to us sometimes and they say, well, the regulatory system is not working because it's not working to protect our health, safety, and welfare. Well, maybe the regulatory system is working perfectly because maybe its purpose was not to protect health, safety, and welfare, but actually to put a layer of protection insulation between the corporations who are doing X, Y, and Z and the communities themselves who have an interest in a much different type of economy or environmental protection. So those calls went on for quite some time. It may have been something in the water in Pennsylvania, I don't know, but communities started refusing to take no for an answer. So, in my mind at least, the reason why people start doing stuff is that the cost of doing nothing becomes more expensive than the cost of doing something, right? That the cost of doing nothing and automatically allowing a project to come in and seeing 60% of their property being devalued and living with the clean air and the clean water pollution, or the air and water pollution problems, that's not a solution. That's not good enough for folks, and that they need to do something, because that beginning to do something is the only thing that stops those things from happening. So a little place called Wells Township in Pennsylvania. So we're talking about south central Pennsylvania, below Harrisburg, right up against the Maryland line, in a place called Fulton County, Pennsylvania. In that county, there's a little place called Wells Township. Wells Township population 500 people. And Wells Township was slated to get 6 new corporate factory farms into their township. So there's small township, 6 new corporate factory hog farms coming in. And so they contacted us, and we went in to speak to them, and we explained to them the system of law, and we explained to them what they were going to run into, and that saying no was illegal and unconstitutional under the system of law, because in essence, that's where we end up, is that because the system of law has been built a certain way, and you run afoul of corporate constitutional rights when you attempt to say no within your community, that you saying no within the community if something is harmful to you is illegal and unconstitutional under this system of law, right? That's where we end up in this topsy-turvy place. So I explained that to them, and they said, well, we want to do it anyway. Right? And I said, well, you can't. And we just explained to you why you can't. You can't because you're going to get sued. And these other things are going to happen to you. And they said, we don't care. And I said, what do you mean you don't care? Right? You're putting the financial solvency of your municipality in danger. I mean, this is real life stuff. Right? You take a stand, corporation sues, small community of 500 people, you don't have the money to pay damage award. So you're putting all that stuff on the line. And they said, we don't care. And I said, what do you mean you don't care? Why would you do it? Because what's going to happen is you're going to pass the law, you're going to get sued, the corporations are going to use the courts to overturn your law, and you're going to get the factory farm, you're going to go into municipal insolvency, and what's good about any of that, right? And they said, well, first of all, we can't allow these things in because we have a family farmer-based economy in Fulton County. We are farmers ourselves. The township elected supervisors are farmers themselves. And I said, well, what do you think is going to happen if you say no? And they said, well, if we say no, maybe the folks next door will say no. And if they say no, maybe the township down the road where I grew up will say no. And then maybe somebody else says no. Maybe it spreads to other places. And maybe at some point, the folks saying no outnumber the folks who are trying to force these things in. And maybe then something real happens. And I remember looking back at them saying, fat chance. That's not how things work, right? Welcome to reality. And they said, well, would you be willing to help us out anyway? And actually travel this path. And we said, well, we're pretty much done with the regulatory system. We were finished with that because we were no longer about helping corporations build better permit applications, which essentially is what the regulatory system had become to us. And we assisted them to write the first local ordinance, the first municipal law in Pennsylvania to ban corporate factory farms in their municipality. Okay? We wrote it, we gave it to them, they passed it. They then became a transmission line to other communities, so they gave the ordinance to other places across Fulton County. Pretty soon, half the county in Fulton had passed this particular ordinance banning corporate factory farms. And then it started to move into other parts of Pennsylvania. So at one point we had, and still do, a dozen communities that had banned corporate factory farms within their municipalities. What happened next was that the corporate factory farm, the factory farm corporations that were coming into that township within Fulton County decided to leave the township. They decided to pull their plans for new corporate factory farms. Mostly because they didn't want to get involved in a legal fight that was going to increase their bills. And why would we put factory farms into this one location when we could simply go next door, where they don't have an ordinance and we don't have to fight through that situation? As the corporate factory farm work was starting to accelerate, another community contacted us who had an issue dealing with corporate sludge dumping. So in Pennsylvania, as with other places, everything that comes out of your centralized sewage treatment plant, the solid part is called sewage sludge cake. Just to let you know that you can't put cake after everything and make it sound that much better. So you got sludge cake, and that cake we used to dump off the coast of New Jersey, which created a dead zone off the coast of New Jersey. The environmental groups then joined with the U.S. government and said, we have a new solution, which is land application of this sludge cake. And so now most of it is applied to farmland, where we grow crops for both livestock consumption as well as human consumption. We've had a couple kids in the United States die after coming into contact with that land-exposed sludge because it contains a lot of nasty things that go airborne, people breathe it in. We had communities in Pennsylvania who had run through the regulatory system with sludge dumping in their community, because guess what? 4 corporations control 70% of sludge dumping in the United States, and they're paid by your municipal authorities to haul it, to give it away to farmers for free on the back end. That the community started calling us and saying, hey, we heard what you were doing with these corporate factory farms. Could you help us do something similar with this sludge dumping? And we said, sure. And so we drafted an ordinance. First one place passed it, then 10, then 100, then we were up over 100 municipalities in Pennsylvania just dealing with sludge, corporate sludge dumping in Pennsylvania. Which meant that we were at about 10% of all the rural townships in the state of Pennsylvania who had passed these kinds of laws. It was the early part of the revolt, the revolution that started to happen, where people said, we're not going to do this anymore. We're just not going to do this anymore. We're not going to listen to regulators. We're not going to listen to the lawyers. We're not going to listen to the elected officials. We're not going to listen to the legislature. We're not going to listen to these folks anymore, because their interests are not our interests, and we're going to do what we need to do here to actually stop this stuff from happening. The watershed point in the early part of this work, in the early 2000s, was when one of these communities got sued. And it was a little place called Belfast Township, right down the road from Wells Township, that had passed the ordinance first. The agribusiness corporations came into Belfast Township with a lawsuit, and on the front page of the lawsuit, it said, we are corporations, we are persons under the law, and your ban on corporate factory farms violates our constitutional rights. Okay? So up until now, it had really been a battle against the issue, whether the issue was factory farms or whether the issue was sludge. It was a battle over an issue, stopping a project from coming in, or a series of projects. The lawsuit transformed that battle over single issues, where everybody's siloed in their own single issues. The sludge folks are over here, factory farms over here, water withdrawal folks are in a different silo. That when that lawsuit came in, it did the work for us in some ways to transform the problem from being just one about corporations and the project they were putting in to becoming about corporate rights. That, in other words, it began to transform people from thinking about individual battles over individual projects to starting thinking about a structural problem of corporations having more rights than the people that lived in the communities where those corporations were attempting to do business. So what happened next was, and it happened pretty quickly, was that these township supervisors that got sued started faxing the complaint all over Pennsylvania, all over to other township supervisors and communities and other people, to let them know that they had been sued, and that there was a bigger problem than corporate factory farms or sludge, that the problem was corporate rights. Basically framed it as a corporate rights issue, the lawsuit coming in. So a lot of times we think, oh my God, I hope we don't get sued. When we do X, Y, and Z, we do something on the cutting edge, and we pray that we don't get sued and hauled in court. Well, sometimes lawsuits are good, right? Because the lawsuit itself begins to frame a new kind of activism and does the work for you that you couldn't necessarily have done yourself. So we were traveling in Pennsylvania talking to people why corporate rights were an issue long before anybody was able to grapple with that fact. We couldn't do it. You couldn't tell people. It had to be shown to them why corporate rights was an issue. And the lawsuit did that in one swoop. It came in and actually turned that table. So the next thing that happened was we had communities in Clarion County over above Pittsburgh who said, look, corporate rights are an issue. We've passed these sewage sludge ordinances in our community, but they're susceptible to this challenge of corporations coming in and suing us. So we got to do something about corporate rights. And I said, what do you want to do about corporate rights? And they said, we want to strip corporations of constitutional rights within our municipality. Right? And I said, you can't do that. Right? I said, why how do you do that? Corporate rights is a Supreme Court issue. The Supreme Court has declared that corporations are persons and have certain constitutional rights. You're at the lowest of the food chain. Because as we all know from school, you got the federal, you got the state, you got the local. You're way down on the local. The federal trumps the state trumps the local. It's drilled into our heads for endless number of years in elementary school, high school, college. And so you're on the lowest rung of the food chain. How are you possibly going to do that? And why? And they said, well, Congress ain't going to do it, right? It's not like we can write letters to Congress and say, hey, you need to get rid of these corporate rights so that we can defend our authority here to stop sludge from coming into this community. That's not going to happen. And our state legislature was the one that legalized sewage sludge dumping in the first place. there were a series of permit and regulatory stuff in the state of Pennsylvania that legalized land application of sewage sludge. So they said, if we don't do it, nobody's going to do it. And they said, would you help us to do it? And we said, yes, we would help you to do it, because we were basically going down the rabbit hole with them. And so we drafted something called the Corporate Rights Elimination Ordinance. We drafted it, we sent it out to the communities, and we didn't think that the communities would actually have the gusto to pass it. But lo and behold, they advertised it in the paper. They brought it up at a public meeting, and people testifying at the public meeting. And just to draw a picture, these are not liberal, progressive communities. This is rural, Republican, conservative parts of Pennsylvania. So places you would not expect, perhaps, some of these things to happen. That's where this work got its start. Was in those very red areas of the state of Pennsylvania. So when you drive up to Licking Township and Porter Township, which are the two communities in Clarence County that began to move with these ordinances, what you find is that they don't even have township buildings to meet in. There's no municipal buildings. What they have are salt sheds, and they meet in the salt sheds for their meetings. So you pull up, chairs around the salt pile in the middle. You have a light bulb swinging back and forth from the ceiling like a bad horror movie, and you have people coming in, sitting on the floor on chairs to actually, do the meeting's business. And that evening I drove up because I wanted to watch what happened, so I sat in the back. You had veterans who came in who had downloaded Thomas Paine from the internet and began reading it about, we were overseas fighting for freedom over there, and we came back and found out that we don't have democracy here. You had farmers reading from the early Pennsylvania Constitution and from the Declaration of Independence. The highest authority of governing power is the people. The we the people concept that we seem to have either forgotten or has been trampled over the last 100 years. And those supervisors in Porter Township became the first municipal government in the United States to refuse to recognize that corporations had constitutional rights within their municipalities. Okay? In their municipality. The next night, Licking Township became the second to pass it. Well, it was fascinating to read the newspaper coverage of what was happening in these townships, because on the headline on the front page it says, "Township says corporations, not persons." On the leader front page of the thing. And people started getting education about corporate stuff and what corporate rights were about, and how it was stopping the communities from actually moving forward in some ways. And then the corporate boys, as everybody knows, for every action there's an equal and opposite reaction. In fact, Youngstown's a good example of that. And in Pennsylvania, the unequal and opposite reaction that happened was that the corporations affected by these ordinances began to cry to the legislature. They went to the legislature and said, we're running into all these ordinances, they're interfering with our work here in these particular communities, and we need to stop them from doing that. The legislature, under a Democratic governor, Governor Rendell, passed a law called ACRE. Agriculture, Communities, and Rural Environment was the name of the piece of legislation. And the legislation made it illegal to pass these ordinances within these municipalities. And the topper was that the legislation placed the state attorney general's office at the behest of the agribusiness corporations for the corporations to call the attorney general's office to come in and sue the municipalities that had passed the ordinances. Not in the name of the corporation, but in the name of the state. Okay? So here are the corporations. They had been chasing these municipalities all around, having to sue them and pay their own monies to hire the lawyers and everything else. Here's the legislature who comes in and says to the agribusiness corporations, all you have to do is pick up the phone and call the state attorney general's office. And the attorney general will dispatch someone to come into the community. And if the community does not repeal their ordinance, that they will sue the community. So Commonwealth versus the township, using your taxpayer monies, right? So we're going pretty quickly here tonight, but this is a doozy. Using your taxpayer monies to fund the attorney general, a public official of the state, to use him as a private lawyer on behalf of the corporations to knock down the municipal ordinances within the state that are being passed against factory farms and sludge and corporate rights. Most people, after that happened, approached us and said, "Oh, we're so sorry that happened, and it was a really bad thing." To which we're thinking, "Yeah, it's pretty good actually," because we were trying to explain to folks that the problem was not the corporation by itself, but that the corporation was enabled to do what it does by the state. It's your government that's the problem. It's not just the corporation. That's just who you run into when the projects come forward. But it's your state. And people would look at us like we were crazy. Well, then the legislature passed this law and essentially framed the problem as the problem's not the corporation, it's not the project, it's actually us. It's actually the legislature. It's the state operating on behalf of the corporation. We use a phrase to describe this relationship, and again, this shouldn't be new to anybody in Ohio, but that you live in a corporate state, right? Where the corporations have almost complete and utter synergy and parallelity with the state legislature and the organs of the state. They become so powerful in many ways that they control your state. And yet, of course, we call this a democracy when it operates much like that corporate state. So, we went through those various stages in Pennsylvania. One little funny story to tell you is that after Acre was passed, we had a small community called Packer Township in a place called Carbon County. They passed one of our ordinances. The Attorney General was dispatched to come into Packer Township to force them to repeal the ordinance. They decided not to repeal the ordinance and in fact passed a new ordinance which suspended the authority of the Attorney General within the municipality. So, a little bit of revolt is a good thing. So what happened next was this work spread. So I'm going to talk a couple minutes about how it spread, and then, what about the lawsuits? I want to talk about that as well. And what's the theory of change here? I mean, where is this stuff headed? Because Youngstown is part of that course. So are communities like Oberlin and Broadview Heights and Gates Mills and other places in Ohio where this work is starting to grow. The work in Pennsylvania spread first to New Hampshire, a little place called Barnstead, New Hampshire, that was dealing with corporate water withdrawals. There was a plan by a water corporation to extract water from their aquifer and sell it overseas, to bottle it and sell it overseas. So the first corporate rights ordinance in New Hampshire was passed in Barnstead and then spread to other communities. In New York, the first community to pass the community rights ordinance dealt with fracking, so it was in the southern part of New York State. In Virginia, folks may not know, but the largest uranium mine in the United States is located in the state of Virginia. And so folks became very concerned about that mining operation and passed a corporate rights ordinance. In Maine, the corporate rights ordinance just chased out Nestle Corporation from a couple communities in Maine, which became the first to pass these laws. In New Mexico, the first county, Mora County, a couple years ago, passed an ordinance banning hydrocarbon extraction countywide. So it was the first county to adopt one of these ordinances. In Oregon, folks are dealing with genetically modified seeds, pesticide spraying, food bill of rights to protect local farmers. In Colorado, community rights ordinances are being used against fracking, to stop fracking operations. In Ohio, of course, fracking, injection wells, pipelines. In Washington State, the city of Spokane, which is my home, has moved forward with both environmental type issues through these community bills of rights that are running in communities, but also non-environmental issues. So this year a worker bill of rights was on the ballot, which would have established equal rights in the workplace, would also have established a family wage that had to be paid, so an increase in the minimum wage within the city of Spokane. In short, 200 communities in 10 states have now begun to do community rights organizing. This concept that you can't just try to reject corporate projects, but you have to go after the structure itself. So preemption as a doctrine and corporate rights as a doctrine, all this stuff has to be unraveled. And the only way that happens if you target it as a structural thing rather than just as a ban. These ordinances that are being passed in these different places are charter amendments or new charters. It doesn't matter what the form takes. They're basically new local enactments where people, I would submit, are doing nothing less than seizing their municipal governments and turning it up against this corporate state apparatus. So they're actually using their municipality to begin to challenge that corporate state apparatus at the state and federal level. They generally contain three portions, three sections. The first section is a community bill of rights. Right to clean air, right to clean water, right to a sustainable energy future. Some folks have begun writing in a right to climate a right to healthier, safe climate to support their work to stop pipelines or fracking and other energy projects. In addition to the Community Bill of Rights, you have a prohibition section, which is a prohibition on those activities or projects that would violate the Bill of Rights. So basically, you're looking at an expansion of rights. We're used to thinking about that, I think, at the state and federal level. So you have a U.S. Bill of Rights, for example, and a state Bill of Rights within your state constitution. This is actually about giving birth to a whole new rights dynamic where the locality begins to expand out civil, political, and environmental rights. And then finally, the last section is an insulating section, which deals with corporate rights, basically saying that corporations don't have certain constitutional rights that would interfere with the lawmaking that's being done within the locality, and doesn't recognize what's called ceiling preemption, where, like in Ohio, the state comes in and says, you can't pass anything more stringent than what we've already put into place under our oil and gas regulatory scheme. So it basically limits the community as a ceiling. Question we get all the time, of course, which is a natural one, is what about lawsuits? These communities begin passing these laws, they get sued. The answer is yes, they do. Although it has been, up to this point, a very small percentage. I think it's about 5%, 6% of the communities that have been passing these laws actually get sued. When they are sued, these communities, the corporations are forced to come at them differently than if they had just passed a ban or an additional regulation on oil and gas extraction. Because the corporate boys are used to coming in to fighting over those issues, parts per million, or setbacks, or the other things that we're used to doing up to this point within the regulatory field. When you do a rights-based ordinance, it forces them to come in and elevate their rights above yours. That's what the litigation begins to look like. So count number one is, we have more rights than you do. That's another way to put it. And in fact, in the places where we've taken on the state attorney general and some of the biggest frac corporations that operate, that count number one will be, there is no right to local self-government. Okay? That's the claim, that the community is attempting to exercise a right to local self-government that they don't have. So again, we've been out telling folks there's no democracy at the local level, you don't have democratic control, but when the corporation comes in and says the same thing, it's less about us trying to convince people and more about people seeing how it works. In Pennsylvania, we had a seminal case 5 years ago where the state attorney general's office filed a brief, and the first page, number one point was, there is no constitutional right to local self-government. Right? That's the law. And we've been trying to tell people that, but this myth and illusion that we live under, sometimes folks don't understand that or can't comprehend it, can't wrap their brains around it. So when we're in court, what kind of defense do we run? Well, we're asking the court to recognize a constitutional right to local community self-government. And we believe that we have a pretty good case. Going back to the Mayflower Compact, going back to the early days of the colonies, we are a self-organizing country. We tend to forget that, I think, sometimes. But nobody asked for permission to organize towns and cities in Rhode Island and Connecticut and Massachusetts that operated outside of the English colonial system. We didn't ask for permission. People just came together and built governments. They came together to create governments. That's our history. And in fact, communities existed long before the United States existed, and long before most states existed. We have a history of community democracy that exists independently of the growth of our state governments and our federal government. It used to be in the late 1800s that was a well-known judicial doctrine, that Supreme Courts of different states, like Michigan and even Iowa in the Supreme Court, has held that there's a right of local community self-government. That's disappeared over the years. But it's not like we're arguing something that's brand new. It's something that's been here in the past. We need to resurrect it, we need to resuscitate it, we need to make these arguments. If you have a right to local community self-government as a constitutional right, then corporate rights become unconstitutional. Preemption becomes unconstitutional. The state actually telling you what you can and can't do from a stringency standpoint on regulatory enforcement and passing local ordinances becomes unconstitutional. We're asking for a recognition of a new constitutional doctrine which will make the existing doctrines that are currently used by the corporation to shut communities down illegal and unconstitutional. So the irony here, of course, is that they say you're being illegal and unconstitutional. The legal defense they're running calls them out as being illegal and unconstitutional and forces the court to pick sides. Now, it's not like courts and judges are going to slap themselves on the forehead and say, hey, for the last 150 years we've been wrong, and now we're going to just rewrite a new system of law, a new doctrine. It's going to take a while, in the courts at least. But I have been surprised. 2 years ago, we had a judge in Western Pennsylvania who wrote a 25-page decision, issued a decision ruling that corporations were not persons for purposes of parts of the Pennsylvania Constitution. Right? Unrelated to us, she arrived at those conclusions herself. Her decision, her ruling actually reads almost parallel to the stuff that we produce for the courts. But corporations have been persons in the Pennsylvania Constitution for the last 150 years. And so here's a judge writing a 25-page opinion saying that corporations are not persons within the Pennsylvania Constitution, which was amazing, shocking even to the legal profession in Pennsylvania. She said that corporations are but grapes to be pruned by the body politic. That was one of the sentences that we enjoyed. So the final part of what I'm going to say tonight is that we don't count on the courts to do the work either. If we were putting all the eggs in the judicial basket, that's like putting all your eggs in a regulatory basket. That we're not saying, okay, this movement is starting and it can't continue until a judge says it's okay. I mean, that's like the American revolutionaries going into English courts asking them to recognize that the American Revolution was legal, right, and constitutional. It's not going to happen. And so overriding the courts, or in some ways, giving them new structures of law to interpret, is an important part of this work. In Ohio, as well as the 6 other states, communities, like the community group in Youngstown, and Overland and other places and other states, you have these communities who are joining hands as well, coming together to form statewide organizations who are beginning to propose new state constitutional amendments. What would those state constitutional amendments do? Well, they legalize what you're doing anyway. You're pushing the envelope in Youngstown as well as the other places doing community rights work. The state constitutional amendments would recognize a state constitutionally secured right to local community self-government and authorize your communities to pass laws under and pursuant to that right, something that you're doing now because we're saying the right exists anyway, which we believe that it does, but this actually gives you a state constitutional platform. Just a couple weeks ago, I was with a gathering of the National Community Rights Network, which is places like Ohio, the Ohio Community Rights Network, coming together with other state community rights networks to give birth to a national organization, which has just approved a 28th Amendment to the federal Constitution, which would create a federally protected right of local community self-government within the federal structure. Okay? And so, essentially what's happening is the infrastructure is beginning to fill out in terms of these state community rights networks moving forward and now proposing something at the federal level. To make it more exciting, I think, even to me, is that we didn't expect any legislatures to begin carrying the ball. Most of this stuff has to happen through citizen initiatives because no legislators are willing to touch this stuff. But in New Hampshire, 2 weeks ago, we got news that 2 Republican sponsors have stepped forward to sponsor the legislation, this proposed constitutional amendment, in the House and the Senate in New Hampshire. So folks are stepping forward, both Republican and Democratic co-sponsors, to begin running these constitutional amendments at the state level. So I think what we see is this giant engine that's starting to build. And the lower part of the engine, the energy coming into it, is the communities actually who are standing up unwilling to take no for an answer. And a lot of times folks still say to us, what's the point? At the local level, they say, what's the point? You're going to pass the law, you're going to get sued, the law is going to get overturned because the law is the corporations have more rights than you. What's the point? Well, they asked the same question to the 4 African Americans who sat down at the Woolworths counter, right? What's the point? You're going to go in, you're going to sit down at the lunch counter, you're going to ask to be served, and you're going to get arrested, and you're going to get hauled away, and you're going to get prosecuted, and nothing's going to change. They said exactly the same thing to those 4 African Americans sitting down at the Woolworths counter. And if you'd asked them, they said, we have a moral and ethical duty to do it, number one, but we also think that if we do it, somebody else is going to do it. And at the end of the 3 weeks, the 3 weeks after they sat down first at the Woolworths counter, there were 300 other groups doing the same thing, right? Sometimes change comes from those people who have nothing left to lose. And the communities in the United States, are in essence enslaved in many ways.